Yes, good evening to the participant of the JCJ 2022 main examination, and yesterday also done the burden of proof, and today also the continuation of it, and mostly the cases that I would like to deal in the today class. Please read what I posted on the screen.
Welcome to the appearance of JCJ 2022 main exam. Burden of proof. Professor Dr. Mohammed Saheb Hussain, Professor of Law School of Law, South
Mwanza, Tanzania, East Africa. Is it correct? Say yes. Salma, welcome to the class. Are you hearing me? Are you hearing me?
Sir.
Say loudly.
Yes, sir.
Keep your gadget very near to your mouth.
Yes,
Then
sir, I can hear you.
when you speak, you unmute. When you don't speak, you can mute it. Now you mute. Okay, now let us see the constitutional validity. Let us see the constitutional perspective, how it would be there. The enactment in the question was passed by the Parliament with the recourse to the Article 253. Article 250 of the Constitution of India that says the provision confers on the Parliament and the power to make the laws in pursuance of the international treaties. If the India would be the one of the member in the convention, ratified the convention, and signatory to the convention, at the time, India should domesticate the convention. So that's why we will say here international treaties, conventions, we have to domesticate it. So the Domestic Violence Act was passed in furtherance of the recommendation of the United Nations Committee on the CEDA. What is meant by CEDA, anyone? What is meant by CEDA? If you know it, you tell me. If you don't know it, you say pass on. Participants, if you know it, you tell me. If you don't know it, you say pass on.
Don't know, sir.
Say loudly. Keep the gadget very near to your mouth. Repeat. Say I don't know. Say pass on.
Don't know, sir.
See, when you speak in a sonorous voice. SONOROUS. Sonorous voice. CEDA means Committee on Elimination of Domestic. Of course, A is against women. Means here not domestic, D with discrimination. Committee on Elimination of Discrimination against the women. That is called CEDA. It is an international instrument, and based on those lines, the Domestic Violence Act is enacted. So the Act encompasses all the provisions of the specific recommendation, which form a part of the general recommendations in the 1992. So review of the important provisions are concerned. The Act, in a bold break from a prior legislation, gives a very expansive definition to the term domestic violence. The very wide definition is given regarding the domestic violence. The term hitherto not even used in a legal parlance. Domestic violence is defined in a comprehensive way in Section 3 of the Act. Which Act? Which Act?
Domestic Violence Act.
Yes, that is the Act. And here I will show you the Act because this Act consisting of, this is the Protection of Women from Domestic Violence Act 2005. And here Section 3, it deals with the definition of the domestic violence. If you happen to see the Section 3, the definition, it is a wide one. Definition 2, and regarding the 3, it says about the definition of the domestic violence. So it is a Class A, Class B, Class C, Class D, Class, again explanation 1, 1, 2, 3. These are all that deals about the domestic violence. They say there is a sexual abuse, physical abuse, verbal and emotional abuse, insult, ridicule, humiliation, name calling, and insult or ridicule, especially with the regard to not having a child or a male child. And a woman doesn't have the child is called a woman who cannot conceive the child is called.
Barren.
If you know it, you tell me. If you don't know it, you say pass on. Don't waste my time.
Barren woman.
Yes, I already told you it is called barren. Barren. Barren woman who could not have the ability to conceive. Is it clear? Say yes. Is it clear?
Yes, sir.
Good. I appreciate. So now let us see the section 3 of the act comprising of number 1, physical or mental or verbal, emotional, sexual, economic abuse. So these are all type of the abuses are there. These are all type of the abuses are there, we can say. Physical abuse means corporeal punishment. Mental abuse, harassing or insulting. Verbal abuse, using the filthy language. Emotional, taking the advantage of the sight of it. Sexual, it is regarding the BBC, body-to-body contact. Economic abuse, that means selling her own property. Jewels, earrings, anklets, chain, nose, ear studs. What are all those things which I just now referred? Sir, vegetables. What are all those things which I referred just now?
Ornaments, sir.
Why you are taking so much time? When I gave the vegetables, at the time you say, sir, those are ornaments. Yes, those are the women ornaments. And the women ornaments, from the waist to the up, all the gold. From waist to the down, all the iron, sir. Waist to the up, all the gold ornaments. And from waist to the down, participants.
Silver.
Sir, brass. Sir, copper.
Silver, sir.
Why you are taking so much time? All that any woman from the waist to the down, they will wear only the silver. Is it clear?
Yes, sir.
Of course, there is a scientific reason also there behind it. Okay, now physical, mental, of course, we already dealt it. Harassment by dowry, even the dowry harassment also. Either the husband or neighbor,
Relatives of the husband.
husband relatives, namely
Father-in-law.
only one,
Mother-in-law also.
only two,
In-laws. All the in-laws.
only two.
Sister-in-law.
Yes. And
All the relatives who belongs to husband. Sir.
Husband and
all
their
the
relatives.
blood relatives belong to the husband, including the consanguinity people also. Okay, so that is the act of threatening to abuse the victim or any other person related to her. Even threatening to abuse it, the victim, like threatening to abuse the victim in the sense either physical abuse or the mental abuse or emotional abuse, or even the any type of the abuse which I stated above. The act deals with the forms of the abuse that were either not addressed earlier, that were addressed in a ways not as broad as done here. For instance, you take, it includes its ambit sexual abuse like the marital rape, which though excluded under the IPC, can now be legally recognized as a form of abuse under the Domestic Violence Act, under the definition of sexual abuse in this act. Because In the IPC, there is no marital rape, they said, but as per the Domestic Violence Act, yes, is the marital rape is there. When she doesn't have physically, mentally prepared for the BBC, and if you force, the husband force her, then we can say it's a marital rape. Is it clear? Say yes or no. Say yes or no. Participant, are you hearing me?
Yes, sir.
But why you are not giving the reply? Sir, we are feeling shy to say the marital rape. But I told you, forcefully making the BBC body to body contact by the husband against the wife, it is a marital rape under the domestic violence, but not in the IPC. That's the same thing it is written. Like marital rape, which though excluded under the IPC. Excluded means not counted. Is it?
Yes, sir.
When you say count, what do you say?
Included.
Good, I appreciate. The definition also encompasses the claims for the compensation arising from the domestic violence, includes the maintenance similar to the provision of the Section 125 of the Code of Criminal Procedure. What the Section 125 says? CRPC.
Maintenance,
Maintenance provides
Is it for whom?
for wife,
Both.
sir. Yes, sir, for both.
Even the parents also.
Yes, sir. Yes, sir.
If you see the CRPC provision of the 125, it will clearly says. Okay, now nevertheless, the claim for the compensation is not limited to maintenance as allowed by the provisions, but we also read it. Other type of the residential order, economic order, preventive order, visitation order, and compensation. We already read in the last class. Is it or not?
Yes, sir.
It is given by whom? Sir,
Given by the court.
say like a Professor Hussain student. Don't say court. You say court. A judge having the first class judicial magistrate or
Metropolitan Magistrate.
metropolitan magistrate, which is equivalent to the first class. Yeah, that is the way that you have to say. It is noteworthy that the maintenance available under this section must be in a correspondence with the lifestyle of the agreed party. Yes. The style of the living of a woman. Lifestyle. Of course, depending upon the foreigner's type, not foreigner's type, a city type, village type, or taluka type, and how they spend the time, and how what they eat it. And these are all depending upon the maintenance of her, it will be done. Regarding the status also, the way that she brought up also. Lastly, the Act identifies the emotional abuse as a form of domestic violence, including the insult on account of the victim is not having any children or male children. So the people will torture. Like I told you just now, a woman who doesn't have the children is called,
Barren woman.
it's say in Telugu,
Godralu.
yes, you are right. I appreciate. Having any children and male children, in sometimes no, if you don't have the male children, they will also abuse. If they don't have the female children, they also abuse. Am I right?
Yes, sir.
Good. But my view is any child, either male or female, doesn't matter. They should be healthy enough. That is my doctrine. Okay, now let us come to the protection of the women and fundamental rights. The statement of the object of the reason declares that the act was being passed keeping the view the fundamental rights guaranteed under the Article 14. What is Article 14?
Right to equality.
What
and
is
equal
15?
protection of law. Equal opportunities. to all
Equal opportunity should be given to all the people, including the women. And 21?
A right to life and personal liberty, sir.
Yes. So these are all the confers the right to life and liberty and native terms, stating that it may not have taken away except the procedure established in law. So when you want to take it away, then you should follow the procedure which is established by law and which is required as a result of the judicial decisions and to be fair, and it should be just and a reasonable. The right to life has been held to include the following rights which are reflected in the act among others. So let us see one of the case law, the right to be free of violence. So it is observed in the case of Francis Corali Mullin versus Union Territory of Delhi Administrator, AR 1981, Supreme Court 746 page. The Supreme Court stated, any act which damages or injures or interferes with the use of any limb, means part of the body, or the faculty of a person, either permanently or even temporarily, would be within the inhibition of the Article 21. If you make an injury to the body, limb, permanently or temporarily, it is come under the inhibition of the Article 21. Because Article 21 clearly says everybody having the right to live peacefully, right to life with the dignity, and right to education even. So in Article 21 is sometimes is called, I told already when I was teaching the MCQ, Article 21 is called Pandora box. Spelling Pandora, Pandora box. Like a Alauddin Chirag. You know what is Chirag?
Yes, sir.
Deepam. Do you know Alauddin Deepam?
Yes, sir.
What it creates? Whatever you say, it creates.
Genie.
Yes. So now the question comes over here. See, this is the Rajasthan State Judicial Academy. So another case law, the right to dignity, it is also Article 21. Am I right?
Yes, sir.
Even transgenders also having the right for the dignity. What do you say in transgender in your local language? Yes. I say either if you don't know, you say pass on. Why you are keeping quiet? Participant, are you there?
Yes, sir.
But why you are not
Pass on,
giving the
sir.
reply? Say pass on. Did you understand my question first?
Yes, sir.
Then why you are not giving the answer? Say pass on.
Pass on, sir.
But why you are taking, even I should say the pass on also. Sir, we know it, but we feel shy. Is it?
Yes, sir.
Hijda. That is a famous word. Or we can say chekka. Or we will say mita also. Okay, now let us give. That is the Ahmedabad Municipal Corporation versus Nawab Khan, Gulab Khan. Yesterday we read this case. Am I right? The Supreme Court emphasizes the fact that the right to life included to its ambit the right to live with the human dignity. Means no one should be insulted. And basing its opinion on the host of the cases that had been decided in favor of the proposition. Even a dignity should be maintained over there. If not, it is also amount to the domestic violence. Under Article
Article
53, Article 21. The right to dignity would include the right against being subject to the humiliating sexual acts. It will also include the right against being insulted. These two facets of the right to life find mention under the definition of the sexual abuse or emotional abuse respectively. So, a praiseworthy aspect of the legislation is the very exception for the emotional abuse as form of the domestic violence. The recognition of the sexual abuse of the wife by the husband as a form of violation to the person is creditable. Especially as such, sexual abuse is not recognized by the IPC as an offense. In IPC, there is no marital rape, but in the domestic violation, it is a marital rape. That is a sexual abuse. These acts fall within the confines the domestic violence as envisaged in the by the act, though the definition would be not limited to it. So that is why we can say it is having the wide ambit. What? Domestic violence. Right to shelter. We already read right to residence. So Chameli Singh versus State of UP 1993 and 22. I believe this 22 is the volume, it seems. Yeah. All ALR, I think the ALR means either Ahmedabad or Allahabad Law Review. 37 page, it was held that the right to life would include right to shelter, distinguishing the matter at hand from right to residence also. If the residence is not given over there, and if the residence is given, but every time privacy is not there, that also comes under the domestic violence. So, in the Gauri Shankar versus Union of India, there also, where the question had related to the eviction of a tenant under a statute. Yes, when a woman is staying over there, at that time, even the eviction also comes, it should be followed as a process for law. Means at least 1 month notice, unless until we already discussed in the Rent Act, what in the Act, no, especially naval officers and military officers and commandants, these people doesn't need to give formally the things. If they want, they can vacate, ask them to vacate it. So that because some privilege is given over there because for their domestic use, if they want to make it out. So that we already studied in that case. But here, residence is there. If you disturb the residence, it is also comes under the domestic violence. Under section 17, the party's right to continue staying in the shared household is protected. Suppose if they are staying in the same roof, and if you don't allow them to stay, it is also amount to the domestic violence. What is this section 17? Which section? Domestic Violence Act section. These provisions thereby enable the women to use the various protections given them without any fear. Darwaza lagao. Without fear or being left homeless. So, even sharing the houses and asking to evict it, and these are all come under domestic violence. Article 14 contains the equal protection clause. It affirms the equality before the law and the equal protection of the laws. That is what the Article 14. And Article 14 prohibits class legislation, but remain classification for the legislative purposes. A law does not become unconstitutional simply because it applies to one set of the persons, not another. See, a special provisions are given to the woman. A special protection will be given to the child. And a special provisions are given to the transgender. Does it mean that it is a segregation? Answer is no. Because they are marginalized, including the disabled persons, the person with the disability, and some type of the reservation is given to them. Am I right? Participants,
Yes, sir.
see, I have to cry, then only you give the reply. You have to give the reply when I say, because I want to know whether you are there or not. Only one voice is coming, yes, sir. The other voice, sir. Only two are there. Doesn't matter. If one also there, I will run my class. No, there are 5 members there. Deepika, are you there?
Sir,
Why you are not giving the reply?
my both kids are quarreling, sir.
That's why you want to keep it mute.
Yes, sir.
Otherwise, the voice will come out. Just now, Darwaza lagao, I told you. Did you understand what it means?
No, sir.
Darwaza means door.
Close the
Okay.
door.
Close the door because I told them not to get inside. But still they are opening and coming. Okay, now let us see that. That's why the children are naughty. Am I right?
Yes, sir.
If the naughtiness not is there, the children, the definition of children is not fulfilled. Okay, let us see the point where a law affects a classification and challenges as being the violative of the online class में उस बाद में बात करता हूँ. Yes, sir. So now the law says over there, where the law affects the classification and the challenge is being the validity of the article, the law be declared valid if they satisfy the following two conditions. What are the two conditions? Can anyone unmute and read? Number one,
The classification must be based on some intelligible
intelligible differentia.
differentia. There must be a rational nexus between the differentia and the object sought to be achieved by the law.
Yes.
As a result,
Yeah, that much is enough. Why this differentiation would be there? Do you agree? Man and woman are equal?
No, sir, not equal, sir.
Please.
equal, sir.
But according to law, they are equal, sir.
According to law, they are equal, but in most respect, is the theoretical equal practical?
It's not, sir.
Yes. Because theoretical, a Muslim man can marry 4 wives. Am I right?
Yes, sir.
What about the practical? Did you see anyone having the 4 wives now in this digital India?
No, sir.
Answer no. So we have to give some preference to the women. We have to give some preference to the even disabled persons. And some people, they born with the genius, and hence the intelligentsia is very much high to them. And some people, and they are marginalized, the intelligentsia is less, and at that time we have to give some reservations to them. That's why we will see some reservation to the women, reservation to the SC, ST, BC, and many, so on and so forth. So that is not a segregation, it is a justification to make them to be also in the stream of your life. Otherwise, they will be marginalized only. So now let us see that as a result of the resulting cases, one of the case law is the EP Rayappa versus State of Tamil Nadu, All India Reporter 1979, and Supreme Court 555 pages. Any law that is arbitrary is considered violative of the Article 14 as well. If it is feel arbitrary, then definitely it is a violation of the Article 14. The provision is significant in putting the stop to the arbitrariness in the exercise of the state power and also in exercise. This no citizen is subject to any discrimination. There should not be any discrimination. At the same time, it preserves the state power to legislate for the specific category of the people. So arbitrariness, how do you make it out? Suppose, let us presume it. An apple is there. And one brother and one sister, they want to divide equally. What method they do apply it? Sir, they will weigh it apple, then equal weight they will take it. There is no weighing machine. There is no balance. Sir, what is there? Only knife is there. Now, you tell me the best way to decide it. I already told once. And we will study this in ADR, Alternative Dispute Resolution. If you know it, you tell me. If you don't know it, you say pass on.
Pass on, sir.
See, one apple. The brother and sister equally should distribute it. And only knife is there. So the principle is there.
Cut the apple
Yes.
in the middle, sir. They have to cut the apple in middle, sir.
See, it is very difficult to make it the middle. So the principle I will tell you. The equation I will tell you. You cut and I pick. Or I cut you pick. How it is? Did you get my point?
Yes, sir. Then only some differences will be there. One will get plus and
See,
one will
that
get
might be difference. That option is that you cut in a such a way that equally cut. Okay, when you cutting it, once you cut it, either the knife go this side or that side, doesn't matter. The other person having the first option to pick. Am I right?
Yes, sir. Yes, sir.
So that is the equation one should have to apply it. And always you have to make it out. Either a woman or a child, doesn't matter. And they want to tell something to you. Please listen to them. Suppose a boy or a child came from the school and he wants to narrate the story. Please give him the chance to speak. In the same way, if the wife comes from your office, please, if he doesn't say also, you say, Aaj kya hua? Please tell me what happened today. Yal చెప్పి ఇవాళ ఏమైంది తెలుగులో. Are you following me?
Yes, sir.
And she non-stop will speak. And when she speaks, then she will feel very comfortable and happy. And there is only one word is there in the ADR. In order to dispute resolution, they say, let the steam off. What is the word?
Let the steam off.
ఆవిరి మొత్తం పోవాలా. Are you following me?
Yes,
The
sir.
stream which is there. So please, you also give them some chance. If your children are coming, ask them and let the steam off. Or if you are married, you say and ask your husband also. But that husband is very attractive. They know, okay, you want to apply the let the steam off. Okay, now let us see the Article 15. There is a definitely discrimination would be there. And a special provision will be given for the woman and child, including the disabled persons. So what is the section 15 says? So it is not about the segregation, no. A provision would be given to them. How much the provision for the ladies? 33%. Am I right?
yes, sir.
Including the parliament elections also, assembly elections also. Then what about the pilot? Of course, they will see it. Whether she is capable of it, okay, she will be made. Okay, the Domestic Violence Act promotes the right of women guaranteed under the Article 14. Already told you that, and 15, yes, there would be some segregation would be there. One should have to follow it. It is not amount to the violation of the Article 15 because some special provisions should be given to them. So, what is the definition of the domestic violence? According to the Domestic Violence Act, it is clearly again said, a protection of the woman from the Domestic Act defines the domestic violence in a series of steps or classifications are there. For the purpose of the Domestic Violence Act, domestic violence is defined as any conduct that is delivered in a habitual or nature and encompasses the various forms of the assault. I say various forms of the assault means it may be the economic, it is emotional, means violence, I am speaking, as the physical violence and verbal violence or financial violence, or we can say economic violence. So these are all comes, the ambit is very much wide. The Domestic Violence Act states that victimized party is impeded from his or her personal liberty through the perpetual violence or settlement. And S.R. Venunath also made it very much clear. Now the word, any person who aggrieved by the spouse, either female or
Male.
male. So that thing will come into that. So why was the Domestic Violence Act passed? That we know it. Why it is passed? What is the reason?
To give some relief
IPC
to the
section 498 capital A is not enough for the harassment. And hence, there are different type of the harassments are there by the husband to the wife or by the wife to the husband. And hence, to fill the gaps, this act is passed. But still, I told you there is a lacunae are there. It is more biased towards
Women.
Woman. If a cunning woman would be there, even after the death also she harassed the husband. Are you following me?
Yes, sir.
See, I told you when I was teaching the law of tort, common law, even it dies also. Common law, even it dies, means చనిపోయింది అనుకుందాం. It will rule from the grave. Is it clear?
Yes, sir.
How, sir?
It will rule from the grave. So
How,
common
sir?
law never die in one way, in another way. So here, under the domestic violence include all actual abuses and are the threats of abuse, regardless whether the action are of the physical or sexual or economic or verbal or emotional. Emotional abuse also there. Are you following me? So economic domestic abuse, according to Domestic Abuse Act. So scope of the act is very wide. And here let us see the scope of this piece of legislation. Now you tell me, this legislation, what type of the legislation it is? Is it fiscal legislation? Is it social legislation?
Social legislation, sir.
No, though it is a social legislation, but it is said to be the beneficial legislation.
Yes, sir.
Like maternity leave. It is a beneficial.
Yes, sir.
Of course, both to them, even the maternity leave for both the people will be entitled. I believe that now the maternity leave is increased from 3 months to 6 months. Am I right?
Yes, sir.
Then what about the maternal leave? Do they increase anything? Even I doubt, because I don't know. Earlier it was only 2 weeks was there, to my knowledge.
Maternal leave means, sir?
Paternity అంటే హస్బెండ్కి లీవ్.
2 weeks, sir.
No, it is not increased.
I think it's a 15 days enough, sir.
Okay. I do admit it. Okay, this Bhartiben Bipin Bhai Tamboli versus State of Gujarat and others, and the crimes journal, I believe it is the Gujarat, while extensively discussing the provision of the Domestic Violence Act, remarked that, of course, it is given the wide area of the domestic violence here. If a woman resigns her fate or the never-ending cycle of the enduring violence, discrimination as a daughter or a sister or a wife or a mother or a partner or a single woman in her life. Of course, women roles are very, very wide roles, because she will be a sister, the mother, then the grandmother, and the wife, somebody's wife. So these are all the roles she has to do it, and hence the woman is having a lot of patience. And again, they will say the reason.
Various roles.
Yes. The reason why most cases of the domestic violence are never reported is due to the social stigma of the society. See, people says, in anger, what we do? Your wife speaks more, you go out of the house, or you keep
Quite.
either quiet, or you keep the ear studs or cotton buds to your ear, but she should not notice it. Otherwise, no, again she will make the quarrel. So that is the way that you have to make it out, because let her anger will go away first. Later on, everything will be normalized. Am I right?
Yes, sir.
Of course, I do the methods in the same way. Otherwise, life is a miserable. That's why I told my students, including my children also, life is the question of adjustability and adaptability. Repeat.
Life is a question of adjustability and adaptability.
Yes, one should have to make it in such a way. Otherwise, you cannot lead a happy life. Be happy what you have with you. So now the meeting ends within 5 minutes. Of course, I don't know why it is not catched. Okay, now it got it. So here what I want to say is, when can you file a complaint in the Domestic Violence Act? We discussed this thing. Who will file? Agreed person. Who is generally agreed person? Either wife or a husband. Am I right?
Yes, sir.
Yes, sir. So that is the reason that we say respondent who alleges to have been subjected to any act of domestic violence by the respondent. The Domestic Violence Act not only covers those women who are or have been in a relationship with the abuser, but also covers those women who have lived together in a shared household also and are related to the consanguinity, means relation with the blood, and the marriage of through the relationship in the nature of the marriage or adoption. So shared house we discussed is undivided family living in the same house. And S.R. Batra and another versus Srimati Taruna Batra, that is the case law AR 2007 Supreme Court 11118. The Supreme Court, with a reference to the definition of the shared house under Article 2S of the Domestic Violence Act, stated that the definition of the shared house in Article Section सारे जहां से अच्छा हिंदुस्तान हमारा, जय हिंद।